would like to welcome everyone. My name is Howard Gould. I'm co-chair of the real estate section for the Beverly Hills Bar Association, along with Elizabeth Dryden. We are excited about our program today about ADUs and how to legally add accessory dwelling units to help increase cash flow on residential properties. I wanted to let everybody know that the program materials were emailed about an hour ago with the 1 hour reminder for today's program. And there's also going to be a link posted in chat for you to access those materials, and that is in chat at this point. So you can access the program materials, although there will be a shared screen by our speakers for this. Our very efficient staff at Beverly Hills Bar will get you your MCLE certificates, usually within about 24 hours. So look for those tomorrow. I also wanted to mention to you that next month's program will be about foreign investment in U.S. real estate, in particular California, with Vanya Habakovic from Irvin Cohen Jessup law firm. In July, we're going to have a program, our annual program from the California Association of Realtors, talking about form updates and other issues that may be relevant to changes that have taken place during the pandemic. And we have a new speaker from CAR who's going to be with us this year. So we look forward to seeing you at those programs. I also want to thank the program chair for today's program was Michael Tashroudian. At the last minute, he got called away, so I'm handling the moderating functions for Michael, but I want to thank him for putting our program together. Our speakers are Tashroudian and Helen Fower. And David is an attorney. He's a 2009 grad of Hastings Law School. He has his own practice, Tash Law Group. He does some plaintiff side employment there, which is not a portion so much relevant to today's program. Relevant to today's program, David is actually a general contractor. He has companies Retrofit One, ADU One, and he does seismic retrofitting, and they also do ADU design and construction, and they handle that from permit through the end of the process, which is where David has obtained all of his knowledge for the program that he's going to give us today in terms of hands-on activity in obtaining ADU permissions and then doing the construction for apartment building owners. Helen is Director of Development and Marketing for ADU and for Retrofit One, and oversees their business affairs and is knowledgeable about some of the local jurisdictional requirements for ADUs, because while it's a state statute, as we'll probably learn, every jurisdiction has its own preferences. And with that said, I want to thank David and Helen for joining us today, and I'm turning the program over to you. And I will also try to monitor the chat and the Q&A, and we'll try to deal with questions mainly at the end, but maybe as we go along as well. Thank you all.
All right. Thank you, Howard. I want to start by thanking the Bar Association. Thank you, Howard, for the very gracious introduction. And I'd also like to thank Michael for putting this all together. So we appreciate the opportunity to present to the bar, and we're hopeful that this will provide some information to the membership about multifamily accessory dwelling units. And that's what we're going to focus on today. Our focus will be on the recent revisions to the California Government Code, allowing for the creation of accessory dwelling units in multifamily buildings. You know, prior to the amendment to the Government Code, accessory dwelling units were only allowed in single-family residential homes, so SFRs we call them. And essentially what it was, you were able, starting in 2017, to build a granny flat, as they're commonly known, or a small house in your backyard, and you could use it really for a variety of reasons. I know people during the pandemic were using these accessory structures as offices, but the great part is that you can rent them out and generate additional income. But the state sort of took stock of the fact that accessory dwelling units were a very viable alternative for affordable housing in California. And in 2020, beginning in January, the state passed a statute amending the government code. I think it was AB Assembly Bill 68 that amended the government code and finally allowed accessory dwelling units for multifamily buildings. So what I thought I would do today as part of our presentation is run through the statute, highlight some important portions of the statute, and maybe as we're discussing those portions of the statute, interjecting with some of the experience that we've seen through planning and also construction as those sort of activities relate to the specific portions of the statute. And then I'll sort of turn it over to Helen. She'll give a higher level explanation on what we've been seeing with respect to the individual municipalities when it comes to the permitting process and also the construction process. So let's see here. Moving on to the first slide here. We're looking at the California Government Code, section 658.52.150. I call this the sort of preamble to the multifamily ADU rule. And as you can see in this code section, you've got a clear expression of legislative intent, and that's at subsection B here. And the legislative intent behind the statute is to encourage localities to adopt multifamily ADU rules that are in conformity with the state's master plan, like a rubric. So that's what the multifamily ADU rule that's coming down in the government code is. It's essentially a rubric that demands local municipalities to sort of conform their individual ADU rules to one master plan that's been issued by the state. And it's really nice because the state has taken an interest in ensuring that there's a uniform application of the ADU rules across the state, because prior to the institution of the rule here, not only was there a sort of patchwork throughout the state with respect to the ADU rules in single family homes, you just couldn't do it ADUs in multifamily homes. So you've got the legislative intent there at subsection B. And then what's really interesting about this preamble is that it sort of goes through the reasons why the statute was enacted. And the reasons are essentially that there's an acknowledgement here that that there is an affordable housing shortage, and you can see that at subsection A7. You can also see that the legislature has acknowledged that ADUs are a valuable form of housing. And finally, you see here that the state has recognized that ADUs are an essential component of California's housing supply. And that's essentially the business that we're in. We're in the business of creating more housing. And I think it may have been 2020 or right before the pandemic, where the governor had come out and said that there are about 3.5 million housing units needed for the state of California, and we're short that amount. There was another statistic that I read recently where the state showed that there was a net decrease in immigration into the state, meaning there were more people leaving the state of California in 2020 than there was coming in. And that was the first time that it happened ever since the records were started being kept. But that was only a 182,000 person shortfall. And with a population of about 40 million, that decrease in population isn't that significant. So there's still a housing shortage in California, and these ADU rules are very important in ensuring that that housing shortfall is corrected. And yeah, so that's the rule. So moving on from the preamble, we're going to get into really the nuts and bolts of the ADU statute. And the ADU statute is codified in the government code as section 658.52.2. There's another sort of corollary statute to this, 658.52.22, which relates to junior accessory dwelling units, which we're really not going to get into today because those junior accessory dwelling units are not permitted in multifamily buildings, but they are permitted in single family homes. So one of the most important aspects of the ADU rule is this subsection A1C, where the local agencies are directed to implement an ordinance that provides that accessory dwelling units do not exceed the allowable density for the lot upon which they're going to be built. And the reason this is important is because, as some of you land use attorneys out there may know, the number of structures that can be built on a particular parcel of real property is limited by the zoning. And I've got a zoning chart here that I probably should have included in my presentation, but it's published by the city of Los Angeles. So I'll take this for example. And I'm looking specifically at multiple residential zoning sort of zoning rules. And you can see here that if you've got, there are several different multifamily zoning designations in the city of Los Angeles. You've got R2 zoning, you've got RD 1.5 zoning, RD2, all the way through RD6. Now, on an R2 lot, you can build up to 2 multifamily buildings, but you've got to ensure that each unit has a per dwelling minimum area of 2,500 square feet. So if you've got a 5,000 square foot lot on an R2 zoned piece of real property, you can only put 2 units according to traditional zoning requirements. However, because the ADU statute exempts the ADU itself from those those zoning limitations, you can add the additional unit without complying with the minimum area per dwelling unit. That's the same for RD 1.5 and RD 2 lots. So an RD 1.5 lot in the city of Los Angeles requires a minimum lot area of 1,500 square feet per unit. So on an RD 1.5 lot, if you've got a 6,000 square foot lot, you can put 4 units according to the zoning regulations and the density restrictions. However, because of the new ADU rule, you can add more units, and we'll get into how many more units you can add a little bit later in the presentation. But the takeaway is that the zoning restrictions do not apply to these ADUs, and it's codified. I think that's really the most important aspect of this rule. Moving on from the density sort of portion of the statute to the rules with respect to the setbacks. So again, the city of this rule, subsection A1D Roman 7, relates to the setbacks that you must comply with when you're building a new structure. The density charts also have setbacks with respect to structures built on a property. In Los Angeles, for example, an R2 lot has a side yard setback of 5 feet, as a front yard setback of 15 feet, and a rear yard setback of 15 feet as well. Now, for those of you that aren't familiar with setbacks, those are essentially portions of your property that you cannot build on. And the reason that you can't build on those portions of the property is that they might be required for fire access. So, for example, if there's a fire and the firemen need to access the rear part of the property, these setback rules ensure there's an unobstructed path for the fireman to carry his equipment and her ladder to the back in order to combat a fire. The ADU rules change the setback requirements. So although the individual municipality might not let you build a unit in the back 15 feet of your property, you can now do that because of the changes at the state level. So does it say here? It does not. It does, yes. So for the whole state now, the setbacks with respect to multifamily properties on the side and the rear yard are 4 feet. There isn't a change to the front yard setback. I think the city planners and the state planners wanted to ensure that there was a uniformity with respect to front yard setbacks, because you don't want buildings built all the way to the sidewalk. But as far as the rear yard and the side yard setbacks, they've all been reduced now to 4 feet, meaning you can build habitable structures in your property all the way up until 4 feet away from the back and the side yard, the back property line and the side property line, which is a very big deal, because all of a sudden you've got much more buildable space, and it's been extremely helpful, I think, in the planning department for us.
David, have you seen any commentary as to how this affects the fire departments and what they're trying to do when they have to access these properties?
You know, we have not seen any commentary from the fire department, but I would imagine, though, that during the legislative process, that there were, all the stakeholders, including the fire department, did have a say in these rules, and there must have been some sort of study done at the state level to ensure that these structures that are built so close to the property line were in fact safe. And we'll see later, there are also rules allowing you to build up onto essentially the property line.
The other question I have about this is, frequently we see properties where the back 5 feet are dedicated easements for the utilities. And this sounds as if you're now building on top of those utility easements, which one would think could cause some major problems when they have to come in and repair something.
Yes, so you still have to honor the easement. So if you do have if you do have a telephone pole, for example, in the rear of the property that's maybe on an alleyway, you will still have to comply with the city's with the utility company's easement and honor it. But there are clearances and waivers that you can request from the utility company, so long as the structure that you're proposing does not interfere in any way with the functioning of the utility.
Thank you.
Yeah. So another aspect of the statute that was also very interesting is the relaxation on the parking requirement, and that sort of happens in 2 places. So we'll talk first about the requirement for parking for accessory dwelling units. Essentially, at the state level, the state is saying if you build an accessory dwelling unit, you're going to have to provide at least 1 parking stall. And that's going to have to be an off-street parking. So if you build 1 ADU, you have to provide 1 parking spot. And there's a very, very important exemption that we'll get to, and that's sort of identified here in Roman 3, where it says this clause shall not apply to an accessory dwelling unit that is described in subdivision D. We'll get to that. But if you don't comply with subdivision D, you have to provide 1 parking spot per ADU that you create, and that parking spot has to be off street, meaning it has to be on your property, and it has to comply with the minimum prescriptive requirements for a parking spot, which in the city of Los Angeles is 8.5 feet wide by 18 feet deep. So you have to ensure that when you're creating these accessory dwelling units that you're complying with that rule. What's really nice is that the city is saying now that you can park in the setback. You can create these parking spots in the setback, and that would include the side yard setback. So let's say, for example, in the city of Los Angeles on Sherborne, for example, or any other street in Beverly Hills. What's another street out there?
Beverly Hills.
Yeah. Okay, let's just take Sherborne, because I've done a lot of work on Sherborne. On Sherborne, there are 50-foot lots, and on the front, you can park all across the 50-foot lot. So the state is now allowing you to park in that 4-foot setback that you previously probably couldn't park in, at least not legally. Practically, yes, you could fit a car into that side yard setback, but legally it wasn't recognized as a spot, and now it is, which I think is a real help. The only sort of issue, not really issue, but the outstanding question that we have that we really haven't had resolved by the city is whether or not you can create parking in that front yard setback. So as I discussed in the previous slide, the setbacks for the rear and the side yard were reduced to 4 feet each. However, the front setback remained. And in most of these multifamily properties, the front setback is about 15 feet. But that's prime real estate to park in, because you've got 15 feet worth of land. You can fit a couple of cars in there. So it's still something that we're dealing with planning to see if we can place these parking spots in that front setback area. Moving on here to subsection A4 is a requirement that if individual cities have ADU statute or ADU ordinances that are not in conformity with the state minimums, that those ADU rules must be changed to conform with the state's sort of requirements. What's really interesting here is that the state is saying that the individual municipalities have no discretion to deny the application for an accessory dwelling unit. And as I was doing the research on this particular statute, I came across an unpublished case where a homeowner sued the city of San Marino for refusing to allow them to build an ADU in their backyard. And it was a case from 2020 after the statute was enacted. And it was very interesting that it was unreported, but it was very interesting that the appellate court, the reviewing court, went through specifically all of these portions of the statute and found that the city of San Marino has no discretion to deny an application for an ADU when the application conforms with the requirements of not necessarily the requirements, but the outlined rules that are set forth by the state. And this provision A4 sort of ties in with the next provision, subsection B of the statute, that essentially stands for the proposition that when an application for an accessory dwelling unit complies with the requirements set forth in the state statute, the city, the individual municipality, must approve that application and allow that ADU to be built ministerially. So when I took a look at the statute initially, I sort of thought to myself, like, there's a little bit of confusion on what ministerial means. I sort of thought to myself, what does that mean? And I thought a very apt sort of comparison is how you seek entry of default, for example, against a defendant that hasn't answered, or how you would seek to recover your fees, not your fees, I'm sorry, your costs by way of a cost memorandum. When these items are presented to the court clerk has no discretion. They must either enter default ministerially or grant your costs ministerially, unless there's a motion to tax costs, obviously, that's filed to challenge those costs. But it's a ministerial act that's sort of like rubber stamped. And that's the beautiful part about all this, is that within 60 days, the city now, because of this mandate by the state, has to give you approval or at least consider your application for the ADU, which really speeds up the development costs of these projects. Because as some of you real estate attorneys out there might know, in order to build a structure from ground up, it takes a lot of time to get the entitlements, to get the permits, to get the plans through plan check with all their revisions, and to get the plans to a point where a permit is ready to issue. Now that the state has said that the municipality has 60 days to approve or at least consider the application, it's a game changer, particularly for real estate investors who are looking for a quick way to value add to their multifamily properties that they're purchasing. And I see this a lot with institutional investors that are purchasing up multifamily properties, and they're now able to add these accessory dwelling units to the multifamily properties, and they're able to do that fast. Because typically what we see is these institutional investors or these large real estate trusts, they come in, they buy up property, and they want to do the value add play, which is sort of get in there, upgrade the units so that they can raise the rent and stabilize the building. Now they can do the value add, stabilize the building, increase the GRM, increase the cap rate by adding these ADUs, and they can do that very quickly. So this ministerial approval provision of the statute is very, very important in my opinion. Now, another great thing about the state statute is that it's got prescriptive minimums that the cities must allow as far as size for the ADUs. And Helen will get into this a little bit later with respect to the allowable sizes in the particular jurisdictions that we're seeing. But the state is essentially saying that the cities cannot adopt an ordinance that does not allow for at least an 850 square foot one bedroom ADU or a 1,000 square foot two bedroom ADU. And if you look down at subsection C2 capital C, this is what I call what's known as the state exemption ADU. So if there isn't any other room to put an ADU on your property, you've got at least the state exemption where you can do at least an 800 square foot accessory dwelling unit that's at least 16 feet high. That 16 feet height limit is stated in the statute. It's not a limit, rather, it's a floor. Essentially, cities cannot ban an ADU that's less, or they cannot require a height limit that is less than 16 feet. They can have a height limit for your ADU that's more than 16 feet, and Helen will talk about jurisdictions that allow that, but they cannot restrict your ADU to less than 16 feet, which has sort of proven to be problematic for us in design and construction, where you've got a city like Los Angeles that's prohibiting ADUs that are over 16 feet because it makes it difficult to design and construct a comfortable two-story unit. But these are the minimum sizes that the cities must allow: at least 850 square foot one bedroom and at least a 1,000 square foot two bedroom. So I'm going to move on now to the parking exemption here. Now, I sort of briefly mentioned this at the beginning of our presentation, that if you have an ADU, if you build an ADU, you have to provide at least one parking spot. However, if the ADU is located within a half a mile walking distance of public transportation, you do not have to provide additional parking, which is a game changer because a lot of people just do not have room on their properties to add an additional parking spot. and so if you look here, subsections D1 through 5, those are the exemptions from the parking requirement. So the most important one I feel is D1, which says, if you're within half a mile of public transit, you don't have to provide an additional parking spot. And we've seen that all of the prospective clients that have contacted us about putting an ADU in their multifamily property satisfy this requirement, D1, that all of these apartment buildings are within a half mile walking distance of public transportation. And I'm going to let Helen take over on slide 9, this next slide over here. This slide talks about the number of accessory dwelling units that you can do. This particular subsection deals with the number of attached multifamily units, and the next slide will deal with detached. And Helen will sort of explain the difference between attached accessory dwelling units and the number you can build, and detached accessory dwelling units and the number of those that you can build.
Hello. So in regards to what's allowed basically throughout the entire state and what has been adopted by most, if not all, local jurisdictions, the general rule for attached ADUs is the up to 25% rule. So if you have X amount of units in the structure, you can create up to 25% of those as ADUs, but they must be labeled as attached, which you can see described here. They have to be either part of an attached garage, a basement, attic, passageway, tuck under parking, some type of conversion that's within the existing footprint of the main structure. That's what they label as attached. In regards to multifamily properties, you are not permitted to build a new structure that's attached to the building. So that would not work. It has to already be part of the existing building. That's what they label as attached, and that's what's up to 25%. Also for multifamily properties across the board, you can do up to 2 detached ADUs. These can either be brand new construction, or it can be conversion of an existing accessory structure, such as a detached carport, detached garage, a large shed, a barn, something like that. You can do up to 2 of those. Some cities right now who have developed their own ordinance are kind of nitpicking with what the state law says. The state law says that cities can have to allow one of those choices. So some cities are saying you have to choose either attached ADUs or detached, and they're not allowing both configurations. Luckily, most cities are allowing both, but there's a couple of cities like Santa Clarita, Long Beach, who are only allowing one of those. In respect to single family homes, with the law of how much you can add, single family homes can do, so all single family homes are allowed up to 1 ADU, a detached ADU or attached. And if the home is owner occupied, you're allowed to do what David briefly mentioned, what's called a junior ADU, a JADU. So if the home is owner occupied, you can also add a JADU, which allows then up to 2 ADUs. However, the JADU must be part of the house already, the home. It could be an attached garage and a conversion of an attached garage, but it must be part of the actual home. So you can actually partition off and permit a JADU. Let's say there's a master bedroom or a larger living room or something like that you wanted to partition off and create as a JADU. It has to have an exterior entrance. But again, in order to have a JADU, owner occupancy laws apply. So not every home or property owner in the single family residences can do that. However, they can also do one regular ADU with the same type of square footage limits, although when attached, you can do, which I'll get into more sizing later, but you can do up to 1,200 square feet or up to 50% of the existing structure, whichever is less.
So this last slide will conclude the portion of the presentation that sort of runs through the statute. What I thought was very important is that this statute has a sunset provision, and it will remain in effect until January 1, 2025. And of that date, and as of that date, it is repealed. We're very hopeful that the state will find that multifamily ADUs and ADUs in general remain to be a viable, affordable housing option, and the statute is renewed. I want to touch about. Well, I guess I can touch on that a little bit later. So I'm gonna turn this over now to Helen again, just to give a brief overview of ADUs in general, and I'll talk about some specific jobs that we're doing now and how the calculation of the number of units fits in to our proposed designs here.
So as David mentioned, the multifamily ADU law is very new. It came out in 2020, allowing the multifamily properties from duplexes all the way up to any unit count to add these accessory dwelling units and increase their unit count on the existing property. So the same general information goes. It's a separate space with its own independent living facilities. You need to have at least a kitchen, a bathroom, and a regular kind of space there for, it could be combined, the living space and room. I already went over this, but again, exactly what the attached units are. Detached can be converted space or can be new construction if it's detached. And setbacks do apply, especially for new construction, detached units. Typically, it's 6 feet, the building separation from the primary structure with the 4 feet around. Some cities are requiring 10 feet. And you would find that in those local cities' ordinances, if it is anything different from the state law, some do require 10. But as the state law supersedes everything, they're not allowed to ask for more than 4 foot on all the way around rear and sides. These are the typical and common ADU locations in multifamily properties. The tuck under parking, which is also where seismic retrofitting has to take place for certain buildings that were built before 1978 or January 1979, which can also be combined actually to the seismic retrofitting requirements with the addition of an ADU. Carports, garages, storage, basements, any uninhabited, previously uninhabited space can be used. We get a lot of questions about unit subdivision that wouldn't be known for ADUs. That would be a completely different path, which I would assume would also change the title of the property and so forth. So for ADUs, it has to have been uninhabited in order to be used. Although cities have been more lenient now with permitting what was called, bootleg units. So if there were any unpermitted units in the past, they've laxed a little with their rules on allowing you to permit them and become legal ADUs, actually.
Okay, so this is one of the projects that we're working on now. This is a building off of the 110 freeway, off the 110 freeway in between the 5 and Pasadena. So you can see here that this is a soft story building that requires soft story retrofit. The picture on the right depicts the building from the front, and the picture on the left is the rear of the building. Now, this is a 10-unit building, and because it's 10 units, we can do 2 attached units. So rather than retrofitting this building in the front and in the back, because you have the soft story condition, the ownership decided to put 2 units there, and the 2 units will comply with the soft story retrofit requirement as well. So a typical soft story retrofit here would be 1 cantilevered column. If you guys can see my cursor here, 1 cantilevered column that would be placed in front of either of these existing gravity columns with a concrete foundation. That's the front. Same in the back, 1 cantilevered column with a concrete foundation. Instead of spending the $70,000 that it would take to retrofit this building with those typical steel elements, what we're doing is we are creating these 2 units. So this unit here is the unit in the front, and I can't read the square footage, but I think it's about 520 square feet. It's a 2-bedroom unit. You can see here, this is the existing gravity column that we were unable to place within a wall. But here is the second gravity column that we're able to place within a wall. So you're able to put a 2-unit bedroom in the front, and the back is a little bit larger. It looks like it's about 650 square feet. Similarly, a 2-bedroom unit. And by walling up the openings here that were previously the areas where the cars would enter, we're able to comply with the soft story retrofit ordinance, because these shear walls are sufficiently strong to stiffen that weak soft story line such that the building is no longer subject to collapsing in the event of an earthquake. What's really interesting with this project here is we were able to take this courtyard area, if you see this picture on the left, and repurpose that courtyard area into parking. So we're able to get 5 parking spots. So although we removed the 3 parking spots from the front, and I believe the 4 parking spots in the back, we were able to place them in this courtyard area, which was very nice. So this is a prime example of an attached ADU. These 2 ADUs are within the existing building's footprint, and it was in a previously uninhabited space like the parking garage. These parking garages are specifically mentioned in the statute, and I think this is by far the most how would I put that? The most economical way to add the ADUs to a multifamily building are in these parking garages, particularly if the area if the jurisdiction that the building is in requires seismic retrofit, like the city of Beverly Hills. City of Beverly Hills requires these dingbat buildings to be retrofit, and putting those dollars into an ADU, you get your return. Whereas with the seismic retrofit, you don't necessarily get a monetary return, but you do have the peace of mind of ensuring that your building doesn't fall down in an earthquake. This is an example of a detached unit where, if you look at the right, there's this parking garage that spans the back of the property here. It's three garages that are 2 parking spots each, and this whole structure is detached from the building. You can sort of see a up close picture of it on the left. Now here, the proposed design is to build a detached unit. You can see it here. This is the detached unit on the second floor, up above and on top of the existing structure there. So you can see the plans here. You've got the second floor plan here on the right, and the first floor plan, which has a room on the first floor, and then the living spaces up on the top. There's also another option for a detached unit where you can sort of build 2 units that are up above the grade and provide for parking underneath. So this is a design for 2 units that are on the second floor, and you've got parking here at the bottom. The problem that we're having here is with these sort of structures is that there's a 16-foot height limit. So it's very difficult to provide enough clearance for parking, which requires 7 feet, and then get enough room for the floor joists and the ceiling joists and still have an 8-foot ceiling height for the unit up on the top. So there have been a few industry trade groups, such as the one that's headed by AGLA, the Apartment Association of Greater Los Angeles, that have been lobbying the state to increase the height limit to 19 feet or even more to provide for more practical designs. To talk a little bit about seismic retrofitting, several jurisdictions in the county of Los Angeles, such as the city of Los Angeles, the city of Beverly Hills, the city of Santa Monica, city of Pasadena, and the city of West Hollywood, require earthquake retrofitting. And the earthquake retrofitting, a typical retrofit, requires the installation, as you can see here, of a steel element that's set inside of a concrete element. We've done about 350 of these retrofits, and they get very expensive. A mid-range retrofit, it can run anywhere between $65,000 and $85,000. The retrofit on this building, there's sort of 2 sides of this building, was about $160,000. The one that you can see here. Instead of retrofitting the building, the ownership could have put, and this we completed this before the ADU rule took effect. But instead of retrofitting a building like this, the ownership could have created ADUs and generated income instead of throwing that $160,000 away. Retrofit and create units. Here are a couple of projects that we're working on. This one's in Hermosa Beach. It's a duplex. We're putting the ADU, a 250 square foot ADU, in the back. This complies with the 4-foot setbacks off of the side yard and the rear yard. This unit is probably going to generate $2,000 a month in rent. Another project here in San Pedro. You can see we've got these 4 parking spots, and we're turning them into 2 studio units. You can see this I section column here. This is going to be part of the earthquake retrofit. There wasn't enough solid walls on this building. Here's a picture of it. The 2 units are going to go in these 4 parking spots here, and this is an elevation. This is how it'll look afterward. But there weren't enough solid walls to retrofit the building with just shear walls with the ADU, so we had to install a cantilevered column. Here's another job.
David, what do you do for parking there? You're taking all 4 parking spots?
We are. All 4 of these parking spots, 1, 2, 3, 4, but the residents can still park right here in the front.
So are you taking parking away from the existing unit, the people renting up above?
Yes. So you can see here, these 4 spots are now going to be this unit up here. And then the city of Los Angeles, under the rent stabilization ordinance, the Rent Stabilization Commission will require you, if your building is subject to the RSO, to give a rent concession to the people who you're taking amenities away from. One of those amenities is parking. And the Rent Stabilization Commission publishes a sort of guideline on how much you have to pay for replacement, for taking, when you take away parking from a tenant. And if your tenant is not satisfied with the amount that you're offering them, they can actually take you to the RSO and the Rent Stabilization Commission, have them hold a hearing, and they can provide evidentiary support for the $400 they want as a credit. So that's something to keep in mind. So that's the job in San Pedro. Lastly, we're doing a design in Inglewood. Here, this is a garage that we're turning into 2 units. This lower portion here is 3 garages, and this upper portion is 1 garage. This one here is going to be a 400 square foot, right here, 400 square foot ADU with 1 bedroom. This one here is going to be about 650 square feet with 2 bedrooms. And I'll show you how they looked beforehand. So this is the larger unit. The larger unit's going to go right in here in the parking structure, in the parking garage right there. You can see how we're going to change it to have windows and an entry door. This is the larger unit. And then here we have the other side of the building where we've got the smaller unit. This garage area, this is how it's going to look afterward. And you already saw the floor plan, and that should be it.
I wanted to add one last thing that's pretty important that everybody asks is regarding property taxes. So with regards to ADUs and property taxes, we always ask how much, or is it going to trigger a reassessment? Something that I have confirmed with the LA assessor and just from general construction, everything like that. The ADU will not trigger a full reassessment, especially of the primary building. So Prop 13 will still stand. However, it will become what's called a blended assessment. So the value of that ADU will be added on top of the existing value of your primary building, and that's how it would be blended. And it would be, I believe, 1% of whatever that value is. So Prop 13 will still stand, and it will just become a blended assessment of the value of the new ADU. It will not trigger a reassessment of the entire property.
Do you know if they'll give some reduction for the loss of parking in the existing building?
That I'm not too familiar with. I haven't heard anything yet if they have if they're going to offer that or not. However, something that we're actually have been trying to do, it's just a matter of finding the right person, especially at least in Los Angeles, something that they're doing in San Francisco, at least, if they are converting their garage and those garage doors, which are, if it's in front of a driveway and they're converting all of that into an ADU or more, that driveway now is no longer needed. You don't need vehicle access on it. So in San Francisco, they're actually increasing the curb and creating more curb now in front of that driveway, which then increases the street parking, the parallel parking. So we've been trying to actually fight for that to get done in LA and the surrounding areas, that if they no longer need vehicle access on that driveway because it's being converted to an ADU, we can at least increase city off-street parking and just build up that curb. So we're at least trying to do that.
Do you know what the rules may be in Santa Monica? Is there anything special in Santa Monica, Beverly Hills?
Mm-hmm. Actually, yeah, at least for Santa Monica, what's special over there is that they have a higher height allowance. So most cities have taken that 16-foot state height limit, and they've almost set it in stone, which they shouldn't, but because as David mentioned, it is very restricting when they allow 2 stories yet have a 16-foot height limit. However, Santa Monica, which is nice, I believe they allow up to, it's 24 or 25 feet, one of those that they allow. And I was just speaking with them today. You can also have a rooftop deck as well, but that is capped at, I think, 35 square feet. And it has larger setbacks also because they want to still provide privacy to your neighbors and not have someone peering over. But they have a higher height limit because one, which I think is awesome, at Santa Monica, you can get better views out there. So that's quite nice. Santa Monica, I believe, also has a larger minimum requirement. So state law all across has, I believe it's 150 square feet minimum for what's labeled as an efficiency unit. Santa Monica's is 220 square feet, which I like a little better. 150 is pretty tight. 220 still is also, but at least you have a little bit more room in there. And for cities like Santa Monica, some people want to be at the beach all day anyways, but they do have, they've increased their minimum requirement for an ADU. So someone with maybe one stall, which previously, if it was under the 8x18, which I think is 144 square feet, that would not be a viable ADU. You would need at least 2 parking stalls to convert in Santa Monica as an ADU, but at least they allow you to build on top much easier.
Have you seen any situations where there's neighborhood CC&Rs that prohibit the additional units?
Right now, no, because as David mentioned, there is the state exemption, the California State Exemption ADU,
but the question, I guess, would be, has the state overruled any local CC&Rs that may have been in place?
Yeah, I can talk to that. With respect to the CC&Rs that may be governing your homeowners association, there's a specific provision in the statute that says that the HOA must either amend its CC&Rs or allow for the creation of the ADU. I just didn't highlight it, but it's there in the statute.
But they are allowed to have, they're allowed to have certain, I guess, requirements, like design requirements or specifications that you have to follow. But HOAs are not allowed to just prohibit ADUs, because again, no matter what, there's always that state exemption ADU, and they have to do this, except I believe when it comes to maybe townhome or condos, it does not apply there. But if you're, a single family residence or anything like that in an HOA, you still have to. They're just allowed to apply design requirements.
And again, if somebody, had a garage they tore down and you got an upgraded garage, and maybe that was permitted, but then they converted it to an office or something else, they're going to have to go back in and meet some current requirements to get that permitted under the ADU statute.
Yes. Yes, a lot of times what the city will want to see is they want to ensure that the foundation, the footing is sufficient to support the structure, and also that the wood frame structure is bolted down to the foundation according to the current code.
Fireproofing as well, I think.
Fireproofing with respect to the separation between the main structure, the house and the garage.
And generally, you're not going to be able to do these in front of an existing house because those setbacks still apply.
That's right.
Yeah, some cities directly ban that, actually. They're not allowed between the street and the front of the building. Some just require that you follow the front setback if you have enough room, but some ban it altogether from the front.
Have you run into other situations where you just couldn't get the ADU approved? And if so, what sort of issues have prevented that?
So actually, there is one city right now, and we've been kind of trying to go through the state handbook with a fine-tooth comb, because I guess it's all about interpretation with the words, because they technically say up to 2 detached. So there are some cities that are trying to only allow 1 when it comes to a detached conversion, but the property owner wants to convert that structure into 2. So some cities are trying to say, no, it can only be 1. That's what the state law says. So that's just kind of in the gray area right now when it comes to how many can you put within an accessory structure. However, luckily, there hasn't been any problems when it comes to just the basic, that 25% rule, as long as it was uninhabited space. And yeah, I think the main issues and probably lie more within the detached and where they can go and how many.
Which requirements are you finding it's hardest to meet when you go in to do these permitting these ADUs and doing the design and engineering?
Yes, I can speak to that. By far, the most difficult portion, most difficult aspect of the design and the construction is getting a 2-story unit, or a unit that has parking on the bottom and livable space up above, because the 16-foot height restriction is just so restrictive. You can't get enough headroom for the clearance for parking, and have a comfortable ceiling height inside the unit. And most of our clients really want to preserve parking, so they want to build these new structures with units on top. And it's just been very difficult. I'm extremely hopeful that AGLA and some of the other industry trade groups that are making a push for the increased height limit will be successful. And I don't think they're going to stop until they are successful.
And actually, La Habra just contacted me, City of La Habra, and they just passed increased height limits, which actually are then just going to defer to whatever the zoning allows. They will now allow two and remove the 16 feet. Something else, it actually escaped me that was difficult. If I remember again, I'll let you know. But there was one other issue that we were running into.
So I suppose if they increase the height limits, that means existing buildings, if they wanted, could also increase the heights that were previously limited.
I don't think so, because you won't be able to add an ADU on top.
I'm not talking about adding an ADU, but if they wanted to put in vaulted ceilings or something like that, just to, maybe the owner lives upstairs or something and he wants a nicer unit, they're now going to have different height limits they can use.
That's right.
Yeah, theirs would always be whatever the zoning allowed in the first place. So, I mean, that still applies to them. And single family, actually, their height limit is much higher. So we're not finding this problem in the limited single families that we have been working with. They're allowed, I think it's also whatever the zoning is, or up to 25, something like that. So there's no problem with height in R1, like single family residential areas. This is really a multifamily height problem.
Another question somebody's asking is this: can you build both a two-story 1,200 square foot ADU and also convert a detached garage on the same property? Or is that?
Yes. Yes, I mean, it depends. As long as it falls within that 25% rule and the up to two detached, and that city allows for both. So if we're talking multifamily, if the city allows both configurations, then yes, you can convert the garage, as well as build a new construction 1,200 square foot, two-story, if that city allows. Some say no to two-story at all, but if it's allowed in the city, you can do that. Like
West Hollywood and Glendale, for example, will not let you do two-story structures.
But Los Angeles does?
Yes.
Anything else about LA rules that we should know?
Yeah, here's another really funky one. I think I showed an example of a garage that was spread across the back of a parcel of property, and it was on the zero lot line. So the garage was touching the lot line. If you want to convert that whole structure into one unit, you don't have to comply with the new setback rules. So you can use the existing structure and put it in there, and you can be on the zero lot line. However, if you want to put two units in that same structure, you're going to have to comply with the setback rules. So you'd have to demolish the structure and build a new one that complies with the 4-foot setbacks.
And something else regarding LA and many areas too that I just remembered that we were running into, the state and the cities are basically part of the things that David went over on how you would be exempt from adding additional parking or replacing parking is if you convert a carport or garage. However, we've been finding the issue if it's just an open, uncovered lot of spots, some cities don't want you to build on top of that. So for some reason, open and uncovered parking spots are protected. However, carports and garages aren't protected. So it's really bizarre. So we've been finding that, but then of course we're able to propose, like David showed you guys, the two-story structure that can still preserve parking underneath. So we've just been running into that issue with one part of parking being protected and the other not. And one other positive, I'd say, though, at least with Los Angeles, is how most cities do put that cap at either the 1,200 square feet or the 850 and 1,000, depending on how many bedrooms you have. LA, which is nice, says that if that space already exists and you're converting it, it doesn't matter if it's 3,000 square feet, as long as it's uninhabited and usable for an ADU, you can use all of that. So that's been really helpful actually too, if somebody does want a larger unit or something like that.
Well, we are just over our 1:30 time limit. I want to thank David and Helen for the presentation. Really appreciate that, and certainly a very interesting new development with these ADUs in existing multifamily units. So thank you, and I want to thank everybody who attended our program today, and hope you've enjoyed the programs that you're seeing put on by the Executive Committee for the Real Estate section. Thank you again, David and Helen.
Yes,
Thank you.
thank you.
Thank you, everyone.